In the laws that that the Justice Department was arguing in favor of, in Playboy and Ashcroft, and in either of those, did you ever suggest or argue that there should be a lower standard?
We did in every one of those cases before Ashcroft. In Sable, which was the first one of them, we argued for something like intermediate scrutiny under Pacifica. In Reno, which was the next one, we again invoked Pacifica and also made a Renton argument very similar to the secondary effects argument that my friends from Texas make here. And then in Playboy, we again invoked an argument based upon Pacifica, and Justice Breyer in dissent made an argument based on Renton. So we made a pitch for intermediate scrutiny repeatedly in this context. We were rebuffed, and I think that's the history that led us to concede in Ashcroft that this was a content-based restriction that demanded strict scrutiny.
So do you think that it's appropriate in this context of protecting children to compromise the strict scrutiny standard?
I wouldn't describe it as compromising the strict scrutiny standard at all, Justice Thomas, but I do think it would be appropriate for the court to emphasize that it's going to be easier for states to satisfy strict scrutiny in this context because of the very unique nature of the interest here. Normally, the government does not have a legitimate, much less a compelling interest in restricting speech based on its content. That's a fundamental principle. Here, though, there's a specific category of speech defined by its content, speech that is obscene as to the minors, where everyone agrees that the state not only has a legitimate interest, but a compelling interest in making sure that minors do not access that speech that is defined by its content. So I think it's going to be much easier for states to show that restrictions that are based on that content are narrowly tailored to a compelling interest.
But will it be easy enough for this law to pass?
I don't know about this law. We haven't taken a position on that.
I know, but I mean, you've been staring at this law for a long time, and this law is pretty similar to 20 other laws that are out there. So you must have some sense, even if you don't want to say particularly this law.
Yeah.
There are 20 laws out there. Are some of them going to pass through the eye of the needle here or not?
So let me say, if the question were framed the way Justice Thomas did, is there some version of age verification that is good enough? My answer is yes.
I'm not really talking about some imaginable version. I'm talking about like some version that states have enacted.
So let me give you a specific example. We defended COPA, the law this court looked at in Ashcroft 2, even after remand in the district court in the Third Circuit and in a cert petition in this court. I have no reason to think that we would come to any other conclusion about a law that looked like that today. The reason I'm hesitating about state laws is that I don't know that there's actually that much variation in the state laws, and all of them raise some questions that we have about Texas's law that we think are questions of what the law means that would inform the First Amendment analysis. So one is this 1/3 requirement. I think petitioners say the law requires age gating of an entire website, even if it has a substantial amount of content that's protected. My friends from Texas say in the red brief that if you segregate out the obscene as to minors content behind an age gate, you don't have to age gate the rest of the content of the website. That seems highly relevant to us. The second one is the issue that my friend alluded to earlier about which methods of age verification are allowed. The amicus briefs in Texas highlight some of these newer biometric methods that seem significantly less restrictive, but there's a question, as the colloquy earlier illustrated, whether Texas law would allow those methods or would instead require some sort of physical identification or transaction records of some kind. And then the last one, which has also already come up, is which minors are we talking about when we say obscene as to minors? I take it that the plaintiffs say that means obscene even as to the youngest minors. When we were defending a similar law in COPA in Ashcroft 2, we took the position that obscene as to minors means obscene as to all minors, as in inappropriate and lacking in value, even as to older minors. I think the law becomes much easier to defend if Texas courts would adopt the same interpretation of the Texas law here.